You can introduce yourself.
Yeah. My name is Ravi Kumar. I am the Secretary of National Health Forum. We are working on the various Dalit concerns. And one of our areas on which we work deeply is the Prevention of Atrocities Against Scheduled Castes and Scheduled Tribes Act, which is called as SCST-POA Act in short. See, this is considered as one of the most draconian law by the government of India, but I feel this is the first law in the country which talked about the victim compensation and which gave several provisions in favor of the victims. Well, if you analyze it, there are three major salient features in it. One is prevention of atrocities, which is the heart of this act. Then atrocities. So whenever an atrocity takes place, how the victims are protected, the rights of the victims, and the compensation to the victims, the immediate compensation as soon as the charge sheet is filed, and the interim relief to the victims, and the TA and DA travel and nearness allowance for the victims to attend to the court. If you look at all those provisions, it's a fantastic act. Actually, it is a very balanced act. It's not a draconian law. However, when you look at the implementation of it, except the preventive measures, they are trying to implement everything. Preventive measures, the provisions under the preventive measures are many. It starts from a simple community-based, inter-community dining to supplying arms to the, probable victims. In the way, see, there is the caste differences are sharp in a village. We can just organize a community lunch, as Gandhi said, or the recent Pune committee in Andhra Pradesh said. Bring people together, in a very amicable way, negotiable way, you can sort out. But if the government, if the district collector and this SP feels there is a potential threat to the scheduled caste people by some caste people or some upper caste people, the preventive measures goes from banning of those identified people who are potential threat to the scheduled caste and scheduled tribes from that area, seizing their arms, and the ultimate is supplying arms to the scheduled caste people and scheduled tribe people to protect themselves from the perpetrators. But if you look at the implementation of it, the Minister of Social Justice and Empowerment website shows 264 districts in the country has been identified as the atrocity prone districts. So what we did in the last year, we filed the Right to Information Act. We filed a question to all these 264 district collectors, asking them one question. As per the Ministry of Social Justice and Empowerment, your district is one of the atrocity prone area with reference to the scheduled caste and scheduled tribe people. As per the SCST-POA Act provisions, you are supposed to identify the atrocity prone areas in your own district and initiate measures to prevent the atrocities. So the question is, have you listed the atrocity prone areas and the police stations in your district? Please give a list. If you have identified the atrocity prone areas, what interventions were made, and to implement those interventions, from where we have access to the funds, and please give the head of account of those funds. When we have circulated, this question was sent to all these 264 district collectors. As per the Act, district collector is responsible for the preventive measures. Once atrocity takes place, it is the district superintendent of police and the deputy superintendent of police comes into the picture to support and to rehabilitate the victims. So when this question was sent to the district collectors, we got only 8 proper answers to this question out of 264. More than 90% of the district collectors have transferred these questions to superintendent of police in their district or district welfare officer. It's very, very disturbing answers we got. It means none of the district collectors who are in charge of this 264 are not aware of the most important law that should be enacted in their jurisdiction. Okay, this is one scenario. If you go back into the history, in the last, 1995 they put up, first time they put up the list of atrocity prone districts on the web, and since then the number of districts is increasing, but some districts are changing. There, for example, in Maharashtra, 4 districts previously which are listed as atrocity prone districts were removed from the list, and they have added 7. Like that, it has happened in many states. Recent updation is all the 16 districts of Chhattisgarh are put under the atrocity prone list. Maybe there is reference with reference to the what I can't say now. I feel it's basically the threat to the kind of activities, nexual activities that are going on in the Chhattisgarh state. But in other states also this continues. My question is, if the government is sincere in implementation of the SCSTPO Act, they should file sumoto cases under Section 4 of the SCSTPO Act against those district collectors and superintendent of police who are in charge of the atrocity prone districts, if any atrocity happens in their district. For example, you take the Kerala issue. The district falls under the SCST atrocity prone district list. But Kerala has happened there. So you have constituted conducted a normal course of investigation as per the provisions of the SCST Act and other PC Acts. But what is the accountability of the district collector and superintendent of police to prevent an atrocity? Your recent Paramakudi incident in Tamil Nadu, the district is also listed under the SCST, the atrocity prone districts, but Paramakudi has happened. How the district collector and the superintendent of police can escape without any trial? So, without implementing the preventive provisions of the SCST Act, it is like any other PC Act. IPC. Under the provisions of IPC, the only thing is that there is a little addition of the Victim Compensation Act. See, if you take from the day one of the independence, the day we adopted the Constitution of India, we said caste is abolished. To ensure the abolition of caste, the government of India has not made any serious efforts, except 41 crores of budget allocation to the All India Radio to make some advertisements while they are transmitting their programs, and another 20 crores to the Doordarshan to transmit some advertisements kind of a thing for social awareness. But at the ground level, there is no way that monitoring or implementation of abolition of caste is being executed or not. I feel as an activist, if you properly implement the preventive provisions of the Atrocities Act, for which there is a budget allocation under the by the central government as well as state governments, you can use those funds to ensure abolition of caste. Not only triple schedule castes, even other castes also. But there is no accountability. Nobody is in question for this thing for not implementation of the preventive measures. So no district. See, if you take another view, there is no district in the country which is safe for scheduled castes and scheduled tribes. Not only these 264 districts. But these 264 districts which you have identified yourselves with the data available as atrocity prone areas, districts, and what are you doing in it? And if you don't do certain measures, if you don't make certain extraordinary efforts, then atrocities will happen. They're happening, and the revenue authorities and law enforcement authorities are going scot-free. Unfortunately, even Dalit human rights activists also not talking about this. They are also only talking about whether the appropriate sections are being, included in the FIR when an atrocity taken to has occurred or not. Whether the victims are being paid TA and DA. These are the things that are being questioned or probed into it. But this is the heart of the Act, which need to be probed into its implementation and ensure this implementation by making the revenue authorities and the police authorities accountable to implementation. Otherwise, there is no security measure.
Is it political organization, Dalit political organization talking about this?
What do you mean?
This kind of message which you are saying to take action on this collector, on this districts, for example, SCST prone area. If they don't take action, is there a Dalit movement pursuing that and asking be accountable, asking the collector to be accountable? Is that?
Yeah, we started raising a demand, but it has not actually gained momentum yet.
Okay. So
the study that we have done, we are going to publish it soon, and then maybe we'll be able to draw the attention of people.
Okay. The other thing is like in lower judiciary, the law enforcement agency is compiled by police and judiciary. And in lower judiciary, there are Dalit reserved seats are there, and there are SCs and STs as a judge. And even in the police bureaucrats, there are. Why can't they do anything? Is there a...
See, it is not easy. Even if there is a one scheduled caste judge or a scheduled caste officer, he's a part of a big machine which got corrupt totally. So one particular bolt or a nut in a big machine can change the scenario. See, the classic example is Kerala. When the Kerala incident took place in Maharashtra, the FIR, the person who was in charge to file the first FIR was a scheduled caste officer. But he did not use the provisions of SCST Act in the FIR. He used only PCR and IPC Act provisions. And finally the judgment was based on the PCR and provisions of under the PCR and the IPC. No provisions of SCST Act are used to punish the perpetrators in the Kerala issue.
Is that because he was forced, or else intentionally he did it, or else?
I can't say. I can't say. Well, something must have been there really to prevent him.
To prevent him. Okay. Anything else you want to talk about this SCST?
That's fine. The other thing is the SCST Act is the section 4 of the Act, which is a penal provision against the officers in charge. For example, if an atrocity takes place, if the officers responsible in that area, if they don't act immediately, they can also be prosecuted under section 4 of the Act. This provision is there only in this Act. Now you don't find a penal provision to sue or to try a officer in charge, a government official, in any other PC or IPC provisions. It's only this Act. But unfortunately, till now, there is not even a single case where the provisions of section 4 are initiated against anybody in the country.
Okay, the other thing is this SCST Atrocity Act, the other non-Dalit population says that you should remove. In Tamil Nadu there are big debate from this OBC population asking to remove this SCST Prevention of Atrocities. That is one of their demand.
Yes.
Since it is not followed, then why do they bother about it?
See, the fear is the Act, the provisions of the Act are very stringent. See, if any person is booked under the provisions of the SCST Act, it's a non-bailable detention or arrest. But everybody gets the bail because the judges, by taking other things into consideration, is the judge has the freedom to give a bail. So like that, it's being watered down by the judiciary and everybody. But I don't know why still people are scared of SCST Act. The way it is being implemented now, it is all the nails and bones of the SCST Act have been removed. How many people are being paid travel allowances to the victims to attend to the court? 90%. Because of which they don't attend the court. So after 2-3 consecutive hearings, when the victim doesn't present, the case gets acquitted. DA. When a victim goes to the court, a daily wage has to be paid to the victim and his supporters also. It's not being paid. There is no guarantee, there is no place, there is no clear, it's not being made clear, neither by the court nor by the district collectors, where the victim should go to get their TA and DA. It's a big confusion, except the Madhya Pradesh government and the Karnataka government, which have made some advancement in paying TA and DA to the victims. No other state has made any provisions, clear provisions. So it's not being implemented. So SC/ST Act, if they use mostly the section 3 of 10, which is a public address, for which you cannot produce an evidence. So the serious provisions of the Act are not being implemented. Their fear is maybe a time might come when the serious provisions of the Act will be, if they are implemented, they get punished. But before that comes, they wanted to get rid of this Act so that they can do whatever they want.
Okay, in your experience, could you tell me what is the future of this Act? How you think after 10 years now?
Okay. No, this Act, now there is a set of amendments that are being proposed to the Act by several Dalit civil society organizations, and they are also negotiating with the Government of India. They are also kind of showing their willingness. NAC is also discussing about it. National Commission for Scheduled Castes is also discussing about some of these amendments. But what amendments will take place is something we should wait and see. But the Act has to be implemented in its full spirit, and there is very little awareness about this Act among the Scheduled Caste people. Most of the educated Scheduled Caste people are unaware of the provisions of this Act. That is why this Act is not being utilized at all. So only when in the grassroots level, if there is a violent action, it's only that they are using it. But the kind of discrimination that is being faced by the students, the kind of discrimination that is being met to the employees, from belongs to Scheduled Caste, they all can use the provisions of this Act. But unfortunately, they are not aware. Several people, the majority of the Scheduled Caste people are not aware of this Act. We have to create a lot of awareness and then ensure its implementation. Then only there is a security and levels of discrimination come down.